Hi, I'm Leonard. As your mentor, I'm here to guide you with proven methods and personalized support to help you succeed in your 12.5 mandatory core course. By the end of this course, you'll have a clear understanding of legal foundations recognizing discriminatory practices and a deeper appreciation for the importance of fair housing and human rights. Let's get started with the legal foundation and its historical context. The first important statute affecting equal housing opportunity is the Federal Civil Rights Act of 1866. The 1866 law has no exemptions and contains the blanket statement that all citizens have the same rights to inherit, buy, sell, or lease real and personal property. This statute is reinterpreted to prohibit racial discrimination. Originally, fair housing, enacted by Congress as Title VIII of the Civil Rights Act of 1968, also known as the Federal Fair Housing Act, prohibits discrimination in housing based on race, color, religion, national origin. An amendment to the Fair Housing Act of 1974 added the prohibition against discrimination based on sex. In 1988, Congress passed yet another amendments to the Fair Housing Act, adding two additional protected classes: persons with mental or physical disabilities and familial family status. Under the 1988 amendments, protected classes include people with disabilities or handicaps. A handicap is defined as any mental or physical impairments that prevents use of any of their major life functions, such as hearing impairment, wheelchair-bound, mental impairment, visual impairment, other physical impairment. The provisions of this act requires that if a person has a disability, a property owner may not refuse to let the tenant make reasonable modifications to the dwelling or common use areas at the tenant's expense, if necessary, to be able to use the housing. Where reasonable, the property owner may permit changes only when the tenant agrees to restore the property to its original condition when moving out. On June 26, 2015, the U.S. Supreme Court ruled that same-sex marriage is legal in all 50 states, giving same-sex couples the same legal rights and protections under the law as any married couple. It has been legal in New York since voted in by the New York State Legislature under the Marriage Equality Act passed on July 24, 2011. The following important Supreme Court issues shaped U.S. policy during the 100 years after passage of the Civil Rights Act of 1866. Plessy versus Ferguson. In this 1896 court ruling, the court ruled that separate but equal was legally acceptable. Therefore, as long as separate housing accommodations or facilities for African Americans and whites were deemed equal, they were legal. This case legitimized Jim Crow laws throughout the country. Brown versus Board of Education of Topeka. In this 1954 landmark decision, the Supreme Court reversed its ruling on Plessy versus Ferguson. It found that separate facilities were, by their nature, unequal. This case was instrumental in the integration of public schools. In 1990, Congress passed the Americans with Disabilities Act, ADA, which prohibits discrimination and ensures equal opportunity for individuals with disabilities who cannot be denied access to public transportation or any commercial facility or public accommodation. This is a condensed overview of the Fair Housing module as part of the Core New York Continuing Education course. Our comprehensive 12.5-hour curriculum is designed to boost your expertise and confidence while ensuring full compliance. Register now for the Cavaness Realty Institute's Continuing Education remote classes and renew your real estate license. And get 50% off. Select the 12.5-hour mandatory core NYCE topics, plus one 10-hour elective, and apply coupon code for the 50% discount. Should you have any questions, please feel free to contact us at 1-800-983-1310 or email us. Ready to take the next step? Click the button below to register now.